Well, thank you for your patience. I want to wish you good morning. I'm very pleased to have all of you here today at Duke Law School for Meeting the Threat, a symposium on counterterrorism. I want to thank especially members of our community for coming out, students, faculty, and of course our honored guests who have come, some of them from some distance, to be here with us for this conference. Today's symposium is one of a number of events that we have hosted at Duke Law School that examine law and policy in the post-9/11 world. This academic year alone, Duke's program in public law has sponsored a significant conference on interrogation, detention, and the role of the executive branch in the war on terror, as well as visits by 9/11 Commissioner Jamie Gorelick, Chief Defense Counsel for the detainees at Guantanamo Bay, Colonel William Gunn, and a number of other academics and practitioners on the front lines of post-9/11 law and policy issues. In April, Duke's Center for Law, Ethics, and National Security will host another major academic conference on terrorism, and we look forward to separate visits from Deputy Attorney General James Comey in April and the Ambassador of Israel to the United States in March. This level of activity on issues of terrorism and national security is not by accident, but by virtue of the fact that the Duke Law faculty is, if I may boast here for a moment, the strongest law faculty in the country on these issues. This is a faculty that includes Scott Silliman, Chris Schrader, Erwin Chemerinsky, Sarah Beal, Robinson Everett, Neil Siegel, Walter Dellinger, and others, not to mention not one but two interdisciplinary centers, the Center for Law, Ethics, and National Security and the Program in Public Law, that have put these topics front and center in their agendas this year. This event is primarily, however, not a faculty-organized event, this event today, but a student-initiated undertaking. An important part of our mission at Duke is to foster the development of student leadership, which we do by encouraging students to take ownership in what happens here and work to make things happen themselves. There could be no better example of such a student than a second-year law student with a long-standing interest in national security policies and law enforcement who made this conference happen. Tyler Friedman had a vision, worked with faculty and staff to plan it, and then devoted countless hours to its careful planning and execution. We are so proud to have him as a member of our community. Tyler Friedman is a Phi Beta Kappa graduate of the University of North Carolina at Chapel Hill, for which he has been forgiven. Originally from Ohio, Tyler spent time between undergraduate and law school working in the criminal division of the U.S. Attorney's Office for the Southern District of New York, from where a number of our guests today come. There he gained experience in 17 federal criminal trials and a number of criminal investigations. He will spend this coming summer working with a law firm of Simpson, Thatcher, and Bartlett in New York City. He's done, I think you will agree, an absolutely fabulous job putting this conference together. And Tyler, please enjoy a moment of applause for your efforts. Thank you.
Thank you, Dean, for your kind words, and thank you all for being here. Good morning, ladies and gentlemen, and welcome again to Meeting the Threat, a symposium on counterterrorism, which is sponsored by Duke's program in public law. My name is Tyler Friedman. I'm a second-year law student here at Duke, and it has been my privilege to organize this event. This event has been a fairly significant undertaking which could not have been completed without the help of several individuals. First, I want to thank Professor Chris Schrader, the director of the program in public law, for his generous support on this endeavor. I also want to mention the invaluable assistance of Diana Nelson, the director of communications here at the law school, and also Dawn Blaylock. Finally, thank you again to Dean Kate Bartlett for her personal interest and encouragement in this undertaking. It is a special part of Duke Law that the faculty is so supportive of their students and their students' crazy symposium ideas. So thank you for your support. I've had a longstanding interest in national security issues and policies, and prior to coming to Duke Law, I worked in the U.S. Attorney's Office for the Southern District of New York, which, as many of you know, has played a major role in terrorism-related cases, and which is represented here today by several of our guests. I was attracted to Duke by the strong national security faculty and programs such as the program in public law, which help highlight the importance of these issues. This is truly a unique event here today. Not often does the public have an opportunity to hear and participate with such a prominent group of counterterrorism officials. Convened at the law school today, we have a distinguished group of both present and former officials who have played and continue to play paramount roles in some of our country's most prominent terrorism cases and whose daily mission is to ensure the safety of all Americans. While our moderators will detail the positions and work of each panelist, let me just say that it is truly an honor to host all of you here today. We appreciate you being here, and we thank you for your service. The goal of this event is quite simple. It's to help highlight these officials and to learn more about what the government is doing in its war on terror and what challenges it continues to face. Of course, the war on terror has been ongoing long before September 11th. The difference is that now the country is more engaged in the debate and has a greater thirst for knowledge on the issues. I expect that by the end of the day, we all will gain an additional perspective on what these folks are doing to help safeguard the homeland. Finally, I want to thank the strong law enforcement presence gathered here today at Duke Law. The law enforcement response to this event has been tremendous, and it is something that I'm especially proud of. It symbolizes the imperative of coordination and cooperation among agencies and of the respect between local, state, and federal officials. We're honored today to host individuals from the Duke Police Department, including Chief Clarence Burkhead, Durham Police Department, the Raleigh Police Department, the Chapel Hill Police Department, the North Carolina State Highway Patrol, and the FBI. I also want to point out the presence of Kevin Kendrick, the FBI Special Agent in charge of North Carolina, who is joining us from Charlotte. I also want to thank Reginald Holley from Senator Elizabeth Dole's office for being here today and representing the senator. We're honored to host all of you. We appreciate your service, and we thank you for being a part of this event. A quick logistical note, this panel will run for approximately an hour and a half, and then we're going to break and reconvene at 1 p.m. For the keynote by Mr. Garcia. Following the keynote, we'll break into the afternoon panel, which will start shortly thereafter. So thank you again for being here today with my personal thanks, and thanks on behalf of Duke Law School. I now turn the event over to former Assistant United States Attorney, Jonathan Leiken.
Thank you, Tyler. Good morning, everyone. It's my pleasure to be the moderator of our first panel this morning, which will deal with the question, where have we been, where are we now, and where are we headed in our struggle to prevent and punish acts of terrorism? A little bit about me. Tyler mentioned that I was an assistant U.S. attorney in the Southern District. You're going to see some themes among the participants of our conference today, some Southern District of New York themes and also some Ohio themes. I'm also from Ohio. I was in the Southern District from 2001 to 2004. I've since sold my soul to the devil and joined a big law firm. That's a joke. It's actually...
It's really not.
Right. I am a litigator with Squire, Sanders, and Dempsey in Cleveland, Ohio. And I'm also an assistant adjunct professor at Case Western Reserve Law School, where I teach two courses. One course dealing with law and policy relating to terrorism, and another, I'm a co-professor with another panelist for this afternoon, Jeff Mearns, who's over there, and we co-teach a course on complex federal investigations and prosecutions. In terms of today's panel, how it will work essentially is I will introduce each of our panelists, and I will ask them each to give a few minutes, between 5 and 7 minutes of introductory comments, and then I'm going to open up the dialogue for questions from the audience, or if you are too lame to ask questions, then I will ask them myself. But I really urge you to ask questions today because this dialogue will be a lot more lively if you guys participate, and it will be included in your final grade. To help you along, and I really do encourage members of the audience to think about your questions right now and start preparing them, and you all have little microphones in front of you, so you don't even have to stand up. There are certain themes that I think are important in this area, and I'm sure that each of our panelists will deal with one or more of them in their comments today. And there are 4 big ones that I find important. One of them is intelligence gathering. How has intelligence gathering changed since pre-9/11, of course 9/11 being the benchmark moment that changed everything for all of us, and how is it now, and how will intelligence be gathered in the future? And to what extent, if at all, do our intelligence gathering efforts impact upon privacy concerns and liberty concerns? Second, technology. What role does technology play in the war on terror, if you will? How can technology be used to keep us safe? And how can technology be used by our enemies to hurt us? And what do we need to know about that, and what do we know today? Third, law enforcement and prosecution. this has changed significantly since 9/11. We see it in the news all the time, and indeed, there's a great deal of confusion about it. I find myself quite confused about it, frankly. And the questions are, where should terrorists be tried? And what laws are on the books to deal with terrorists? What rights will we afford people that are charged with terrorism? And fourth, public perception. How does public perception play into this area? What importance is there in the public's understanding of the government's efforts to combat terrorism? How important is it to make the public feel safe? How important is it to make the public feel threatened? And to what extent should our government view the public as consumers of our counterterrorism policies? The distinguished experts on our panel today have dedicated their lives and their careers to answering these questions, and I urge you to pick their brains, as I will, over the next hour and a half. And it's now my pleasure to begin introducing them, and after I introduce them one at a time, I'll ask them to give their opening comments. Our first panelist is Admiral David Stone, who's sitting directly to my left. He's the Assistant Secretary of Homeland Security for the Transportation Security Administration. He was nominated by the President for that position on April 8th, 2004, and he was confirmed unanimously by the Senate on July 22nd, 2004. TSA, if you don't know, is the largest of the 22 agencies within the Department of Homeland Security. It employs over 45,000 federal screeners at 450 airports across the country to keep our airways safe. TSA also oversees rail and highway security. Admiral Stone has actually served as head of TSA since December of 2003 when he was named acting administrator, and before that, he was the Federal Security Director at Los Angeles International Airport. His career protecting our transportation industry followed a distinguished naval career, including time in the Pentagon and as commander of NATO's standing naval force during the conflict in Kosovo. Please join me in welcoming Admiral Stone.
Thank you. Grateful to be here at Duke Law, and I want to thank Dean Bartlett, Tyler for the great work, and the entire team for a really warm welcome and a chance to share with you your organization, the Transportation Security Administration. It is the largest part of the Department of Homeland Security. The department has 180,000 employees, and the TSA has 53,000 of those employees. Roughly 47,500 of them are screeners at our nation's airports. So it's a very large organization. Our budget for this year is $5.3 billion. Our focus of effort is on not only aviation, which gets the majority of the attention in both the media, but also we are responsible, as was indicated, for mass transit and rail and highways and pipelines, and also in partnership with the Coast Guard for maritime security. And we have an additional portfolio in shipping and postal, which we're working very aggressively to close some of the gaps and vulnerabilities in that arena. The overall philosophy of the organization, there are three things I wanted to focus with. One is that we want to always be promoting access and growth. The transportation sector of our country is the lifeblood of our economy. And so the actions that we take must reflect that we want to ensure that the key transportation modes are open and accessible, and that there's a smooth flow of goods and services through them. It does no good to have an airport with 100% security that no one comes to. And so I use that as one example of that we're well aware of the fact that our job is to promote growth and access. Additionally, we're responsible for enhancing security, and not just security for security's sake, but risk-based security, and so that you have a priority in what you're doing, and you're applying only what security is necessary in order to protect that particular mode. And thirdly, but probably most importantly, is we want to make sure we're always preserving our freedoms as we go about the job of ensuring access and providing that security. The vision statement for the entire Department of Homeland Security reads, preserving our freedoms, protecting America, we secure our homeland. And that preserving our freedoms phrase is first for a reason, because we want to do no harm to those freedoms that we love as we go about the business of protecting America. And that philosophy permeates our entire organization and the decisions that we make. In addition to that, it probably would be helpful to have a sense on how we spend our day. The core of our day at TSA headquarters, which is located in Pentagon City, just across the street from the Pentagon, is spent on intelligence and operational risk mitigation planning. Each day we have about a 2 to 3 hour session chaired by the administrator and our leadership team of about 30 to 40 people. And we start our day with about a 30 to 40 minute brief on intelligence. And that brief is not only one just of the intelligence of the day, but a trend analysis of intelligence, or what are we seeing with regard to trends in all of the modes of transportation. And then we take a brief that consists of a review of the events that took place in the previous 24 hours throughout the transportation sector. And that's a very lengthy brief because there are a myriad of events that take place that are security related in aviation, with 1.8 million passengers per day that we're screening. You can imagine the number of particular events or intrusions or accesses along perimeter fences that we monitor to see if there's any trend to those, as well as taking on-the-spot action to mitigate the risk of that happening again. And so an intense effort to make sure that we have that domain awareness, that intelligence, and then we're taking daily actions to ensure that the security is enhanced throughout the sector. The current events that are on our plate today, primary one is that we're developing what are called the modal plans, and these are plans for the modes of transportations that I mentioned, of mass transit and rail and highway and pipeline and aviation maritime. And what those plans consist of are we look at the threat, the intelligence, we look at the vulnerability of the assets in this country, and then we look at their criticality. How important are they? Where do they rank in terms of if damage was done to them, how would that impact the security of the transportation system? And then we take those three ingredients of threat, criticality, and vulnerability, and we make a risk-based decision. And that plan then outlines for all those modes our roadmap for how we're going to secure the United States transportation system. Currently, that plan, which TSA developed, has been reviewed by the Department of Transportation as well and will be sent out to all the stakeholders next week for their comment. This will give the opportunity for the trucking associations, the airport associations, all those groups that work in the actual environment and really know it best to comment and tweak that plan. And by the 1st of April, we're required to submit that plan to Congress. And so that roadmap for transportation security is absolutely critical to us. Additionally, the other programs that are very important are the Registered Traveler Program in aviation, where individuals volunteer background information and provide an iris scan or fingerprint, and we're able then to have that and remove some of the hay from the haystack and allow those individuals to pass through our passenger screening checkpoints with a far less intrusive process. And so right now we have 5 pilot sites, but in 2005 we anticipate that program will expand. It's a win for security, but also for customer service, which is one of our missions as well, is to provide not only world-class security, but world-class customer service. And so the Registered Traveler Program, both domestically and internationally, is a high priority item for us. Additionally, there's a program called Secure Flight. This is a program where we're looking at taking the lists of no-fly and selectee individuals. And those lists, by the way, as a result of the 911 Commission recommendation that they be more robust, have grown significantly in the past year. From about a year ago, those were about 6,000 total names. Today, there's 74,000 names on those lists. The current process has the airlines adjudicating those names at the ticket counter, which is an intensive affair for each airline to hire people to, when you check in at the ticket counter, to ensure that the name that you have submitted your ticket under is not the name on those lists. And so that also is an intrusive process. It causes delays, irritations, people not being able to use the kiosks, individuals thinking they're on the list because they're being held up while the airline adjudicates that. The program called Secure Flight will bring that program under the government umbrella so that those lists are no longer promulgated to airlines around the world. So from a security point of view, there's a goodness to it. But also for the customer piece of having a much smoother and efficient process, our ability to adjudicate those names vice the airlines will reduce those near miss and near match names and have that system be a far more efficient and effective one for the traveling public. So both those programs of Registered Traveler and Secure Flight are key programs for us, in addition to a good roadmap called the Modal Plan. In closing, I wanted to briefly say that we have a philosophy that we talk about frequently, and it's probably related to my maritime background, but it's called the 3 ships. And those 3 ships are leadership, and partnership and friendship. And I wanted to say briefly a little bit about each one. Under leadership, the three things we mention and talk about are leading people. It's imperative that we be an organization that are truly covenant leaders, where the professional growth and development of all those under our charge is our primary responsibility as a leader. With 53,000 people depending on us within our organization and the American public counting on us to get it right, very low attrition rates and high retention rates are key to TSA's future. And so you'll see continued emphasis on investing in the training and the quality of life and the quality of work of our people. Also under leadership, leading technology. Programs such as Register Traveler, which use biometrics, as well as programs that lead to a better detection capability at our nation's checkpoint, where we can move away from X-ray machines and walk through metal detectors and have portals that will be able to detect explosive residue on an individual's person, are also crucial for our success. We know last year with the downing of 2 Russian aircraft, where terrorists came aboard with thin sheet explosives strapped to their bodies and detonated and brought those planes down. That threat is a real threat. And so you'll see this year the acceleration of that technology of portals at our nation's airports, which will also reduce the intrusive torso pat-down checks that are being done as a risk mitigation measure until that technology is out into the field. And then finally, under leadership, leading change is crucial, that we're an organization that's constantly evolving, changing, the threat changes, as well as we as an organization are changing to ensure that our local federal security directors and our local entities are empowered to do more rather than have that centralized at headquarters. Under partnership, the international outreach, both with the international civil aviation community, our European allies, is also a key focal point for us in 05. Working with our stakeholders, law enforcement, airlines, airports, rail authorities. Nothing really can be achieved without that spirit of partnership. It's the key to success. And finally, in the area of friendship, the definition of friend, one of them is those engaged together in a common struggle. And we truly are friends in the endeavor in the war on terror. And so it's crucial that customer service, respect for privacy, preserving those freedoms resonate in all that we do. And so it's a pleasure to be here today with leaders and partners and friends and talk a little bit about TSA. Thank you very much.
Thank you, Admiral. Our next speaker, Andrew C. McCarthy, is my former unit chief in the Southern District, and as a young assistant, I can't think of anyone that I found more terrifying. He was scary because he was so keenly intelligent, eminently knowledgeable about vast areas of law, demanding of others and himself, and extremely loud and tall. Once you get to know him, though, Andy is truly a gentle giant, someone who's uniquely dedicated to justice and doing the right thing, and he taught me an incredible amount. He's one of our nation's true experts on terrorism issues, having dealt with these issues as a federal prosecutor for more than 10 years with the U.S. Attorney's Office for the Southern District of New York, where he prosecuted and investigated some of the most high-profile terrorism prosecutions that we've had in this country. And on 9/11, Andy was named put in charge of the leadership of the U.S. Attorney's Office command post in New York City on that day. He's now a senior fellow at the Foundation for the Defense of Democracies and a contributor, seems like just about every day, to the National Review Online and National Review. Please join me in welcoming Andy McCarthy.
Thank you for the kind introduction, John. I'm really not in a position to give him raises anymore, so I'm sort of surprised that you continue to say these nice things, but I do appreciate them. And it's a pleasure and a privilege to be here at Duke this morning. John mentioned National Review Online. I was a little bit reluctant to come down south this morning. I made the curious decision last week because I found the historical parallels to be interesting, writing an essay on the seeming similarities between the Iraqi election, the historic Iraqi election of last Sunday, where there was a lot of criticism about the legitimacy of it, given the fact that people in many areas wouldn't be able to vote because of the security situation. I thought there was an interesting historical parallel between that and the election of 1864, where a number of the southern states were not obviously able to vote in the middle of the Civil War. My friends at the Southern Appeal blog responded that I had lost my ability to discern the difference between the honorable Confederate soldier and the al-Qaeda terrorist. And consequently, it was with some trepidation that I got on the plane this morning. But I do sense I'll probably get out alive, barely. What I'd like to talk about this morning is really the need for some creative thinking about a third way of dealing with terrorism prosecutions. We hear that sort of trite expression, third way, quite a lot, but I think this is a place where it's really apt. And the reason is we currently have two paradigms, and I think that most people would agree that they're not entirely satisfying, either one. The treatment of terrorism cases in the criminal justice system versus the treatment of terrorism cases in military tribunals, or at least outside of the civilian courts. It's frequently been asked, can the criminal justice system work for terrorism? And I think the answer to that question, like many questions, really depends on whom you ask. There is on one side, a perspective of legal scholars and lawyers, legal practitioners, and then there is another perspective, an entirely different perspective, from the point of view of national security. As far as we in the legal community are concerned, I think we can say with confidence that the criminal justice system works because we have empirical evidence that it works. It's worked repeatedly. We've used it repeatedly. Beginning in 1993, we prosecuted terrorism cases a number of times between 1993 and 9/11. Those trials, by virtue of what we know from everyone who's reviewed them, have been found to be a model of due process. We accorded in our system, notwithstanding the fact that we were dealing with an enemy that actually sought to destroy the United States, extraordinary privileges to these worst of all defendants who have really ever entered our criminal justice system. In terms of counsel, they not only receive counsel, as every defendant does in our system, but unlike many of the defendants who come into our system and can't afford counsel, they were actually often given a choice of counsel off the various Criminal Justice Act lists and permitted to change counsel repeatedly until they found a fit that was comfortable prior to trial. They received an overwhelming amount of discovery, which I'll have a little bit more to say about in a few minutes, but really extraordinary if you think about the fact that I think we realize now we've been in a war for quite some time, and this was our most sensitive intelligence that we were handing over to really an enemy during wartime. The pretrial proceedings were extensive and very solicitous of the rights of defendants, whether they actually had the rights or not. I'm reminded always in these contexts of a guy by the name of Muhammad Abdul Alawali, who was the person who drove the bomb-laden truck into the embassy in Nairobi, Kenya on August 7th, 1998. And that explosion resulted in the deaths of well over 200 people. At one point in the litigation leading up to the trial, Alawali confessed to having been involved in the bombing. But that confession was suppressed and almost was not able to be used. It required an extensive litigation in order to get that confession in. Without that confession, Alawali would not have been convicted. The rest of the evidence simply, the case was not convincing enough, absent, at least in my view, absent the confession. Why is this worth mentioning? Alawali was a Saudi who was pretending to be a Yemeni. He was in the custody of Kenya, not the United States, and his only contact with our country was to have blown up our embassy. He had never stepped foot inside the United States. He had no immigration status or immigration contact with our country. His confession initially was suppressed because he didn't receive Miranda warnings. Now, that seems, it seems bizarre to me. It seemed bizarre at the time. Miranda is a doctrine, of course, which is founded on the notion that the police should make sure that a suspect adequately understands his rights before speaking to his detriment. Alawali was in the custody of Kenya, where if the police had given him accurate Miranda warnings, they would have been lying to him because he didn't have a right to counsel at government expense. So what the FBI agents did in that instance was give him an accurate assessment of what his rights were in Kenya. And because the Supreme Court had held in Dickerson the year before we litigated this, that Miranda, which they had said for 30 years was not part of the core of the Fifth Amendment, suddenly was part of the core of the Fifth Amendment. The failure to give Miranda warnings to Alawali almost resulted in the loss of his confession and almost resulted in the acquittal of somebody in a war who had killed over 200 innocent people. I think a lot of the reason why that happened was because when our system is challenged in an existential way, as it has been in the terrorism prosecutions, our ethical, honorable intention, particularly as lawyers who are trained and brought up in the system, is to say that our system, in all of its majesty, attributing all of the rights and the vast panoply of rights that a criminal defendant typically gets, is up to the task of taking on terrorists. And I would suggest that our experience suggests that perhaps that's a little bit too much confidence in the system. Why does the criminal justice system not work for terrorism from the perspective of national security? Consider this. In the 1990s, Al-Qaeda grew from a fairly small organization to having as many as the estimates vary widely, but between 10 and 50,000 members internationally. It grew steadily throughout the 1990s. While that steady growth occurred, during a period of time from 1993 until September 11th, 2001, when prosecution in the criminal justice system was the primary and nearly exclusive counterterrorism tactic employed by our country against our enemies, we managed in 8 trials, most of which took longer than 6 months to complete, to neutralize exactly 29 terrorists. The 8 cases were the 93 World Trade Center bombing, which actually resulted in 2 different trials. The case I handled, which involved the organization of Sheikh Omar Abdul Rahman, the so-called Blind Sheikh, what's been called the Manila Air Plot, which involved the plan to blow up American airliners as they were in flight over the Pacific, the embassy bombings that I've mentioned, the Millennium Plot, and finally, there was another trial that came out of the embassy bombings involving a defendant who, prior to trial, using the rights that we accorded him in our system, took advantage of the ability to meet with counsel in prison to assault a prison guard, nearly killing him in an escape attempt. Those are the events that precipitated those trials. Consider also that in light of the fact that the criminal justice system was our principal counterterrorism measure, that no response at all prior to September 11th was made to the 1996 bombing of Khobar Towers, which resulted in the deaths of 19 airmen, and no response at all to the 2000 attack on the USS Cole, which resulted in the deaths of 17 naval personnel. It's important to consider not only the paltry number of people that we were actually able to neutralize in the middle of what was truly a war, but also the fact that as a practical matter, we couldn't have done much better in the criminal justice system than we did. As a legal matter, the evidentiary hurdles of prosecution, the burden of proof in a prosecution of a criminal defendant, coupled with the fact that with respect to those who we didn't prosecute but who were on the government's radar screen, the hurdles to prosecution were the fact that if you go forward, arrest people, and indict them, you have to compromise methods and sources of classified information. As a practical matter, as a legal matter, prosecution of beyond the 29 people who we actually were able to prosecute in those years was highly unlikely. Secondly, there's a security infrastructure that is absolutely necessary to terrorism prosecutions. They cannot take place every place in the country. Courts need to be secured. Court personnel needs to be secured. You have to have prison facilities that are capable of dealing with what is a real security challenge. Simply stated, we really, even though 8 trials and 29 defendants sounds paltry, we really, as a practical matter, could not have done better than we did. Let me just suggest that, because I don't want to go on too long, I want to make sure we have time for questions and I don't chew up everybody else's time. But I really do think that what we have here is a classic case of trying to fit a square peg into a round hole. We're dealing here with 2 very different executive powers, domestic policing and national security powers. And I think they're importantly different, and the way I would think about them is this. In the domestic policing context, the government has a monopoly on the use of force. When government acts, it's not to suppress existential threats, but rather to stop an errant member of the body politic who is in violation of society's laws. In that context, courts are interposed to protect Americans from oppressive action by the executive branch. We impose burdens of proof before government can invade privacy or deprive liberty. And we presume innocence because the balance our society strikes is we would prefer to see government lose. We would prefer to see a guilty person go free than see a single innocent person prosecuted successfully. That's our criminal justice system. It's rightly the envy of the world, and we wouldn't want to change a whit of it for anyone who's properly in it. But in the national security context, we have a much different scenario. The government does not have a monopoly on the use of force. Other nations, subnational militias, and international terrorist organizations all claim the right to use massive and lethal force. We're not in a position of correcting an errant member of the body politic who has violated our society's laws. Rather, we're dealing with external threats to American society itself, threats to the order on which all of our liberties depend. The balance drawn here is not that we prefer to see government lose, it's actually that we can't afford to have government lose, because if we want to continue to have the society that we have and we want to continue to have the rights that we hold dear, this is a situation in which government has to prevail. And under those circumstances, I don't think a wise country takes its enemies who are posing an existential threat to it and treats it as defendants, presumed innocent, with all of the glorious panoply of rights that we rightfully accord to criminal defendants who are properly in our system. So I hope we'll get a little more chance to talk about that this morning. And thanks a lot for having me here. I appreciate it.
Thanks, Andy. Our next panelist is Anthony Barkow, who is currently a member of the Organized Crime and Terrorism Unit, arguably the elite unit in the U.S. Attorney's Office for the Southern District of New York. Tony came to the Southern District in 2002 after spending 4 years with the U.S. Attorney's Office in the District of Columbia. From 96 to 98, Tony worked in the U.S. DOJ Office of Consumer Litigation. He was a law clerk to Southern District of New York Chief Judge Thomas Grasset and a 1995 graduate of Harvard Law School. Please welcome Tony Barkow.
Thank you, John, and thank you to Dean Bartlett and to Duke for having me here, and thank you to Tyler for putting all this together. I'm really pleased and honored to be here. Before I start my remarks, I just want to make 2 disclaimers. One being that nothing that I say to you today should be taken as a statement of official policy by the Justice Department. And secondly, that nothing that I say should be taken as a statement about any of my cases that are currently pending I'm not talking about any cases that I'm currently working on. So I just want to make those two things clear before I continue. What I want to do is I want to talk about and tell you about some of the statutes that are used currently to prosecute crimes of terrorism and people associated with crimes of terrorism. And what I want to do is divide that into three different kinds of scenarios that we approach the situation with. The first category would be those people who you might think of traditionally as the terrorists themselves, the people who actually perpetrate acts of terrorist violence and are caught. The second category would be those who support the perpetrators of terrorism and those who are providing support in different ways to terrorism, whether it be financial or by providing equipment or weapons, what have you. And the third category is the prosecution of persons who are suspected of committing acts of terrorism or planning acts of terrorism or of associating with persons who are committing or planning acts of terrorism, but who are not actually being prosecuted for committing or supporting acts of terrorism per se, but instead are being prosecuted for non-terrorism crimes. And kind of a common example that people use for that is the Al Capone theory of prosecution, where you prosecute someone who has been identified as a threat and a bad person for something that doesn't necessarily have to do with what they are a threat, in his case, tax evasion. So, and I'm going to comment at that point as how this is a theory of prosecution that is somewhat analogous to, but is critically different than a theory called the broken windows theory of prosecution, which has been discussed in academic literature and by some practitioners. So the first category that I mentioned are the statutes that can be used to prosecute the actual perpetrators of terrorism. I'm not going to go through them exhaustively, but just give you a few examples. The first is in the United States Code, Title 18, Section 2332, little b. And that covers acts of terrorism that transcend national boundaries. This statute was passed in 1996 as part of the AEDPA, or Anti-Terrorism and Effective Death Penalty Act of 1996. It's not part of the Patriot Act. And this statute is one that criminalizes the killing or kidnapping or assaulting, maiming, or threatening of others, or the conspiracy or attempt to do that. And also the creation of a substantial risk of serious bodily injury by the destruction of property or attempting or conspiring to do that. And this statute is one that covers attacks that occur either within the United States or outside of the United States. And the penalties for this offense are serious. If death results or if a kidnapping occurs, the maximum penalty is a life penalty. And the penalties are reduced for threatening, maiming, or property crimes. The penalties for conspiracy or attempt are the same as the substantive offense. And so that means that in the case of a conspiracy or an attempt to cause death, for example, the penalty would be the same as the substantive offense. And this statute covers all conspirators and all accessories after the fact as well. And I'm going to comment a little bit on some issues that this raises in a moment, but I want to mention another statute that's used in this context, and that is Section 956 of the U.S. Code, Title 18. That covers conspiracies to commit murder in a foreign country. And this statute is used to prosecute people who are conspiring to kill people abroad. The first statute I mentioned covers attacks within and outside of the United States. This is one that covers people conspiring to kill people outside of the United States. And so this is focusing on people who are using the United States as a launching pad or a base of operations to commit terrorist action abroad. This statute was amended again in 1996 to include this particular provision I'm talking about, so because the statute previously only covered destruction of property. So again, this is not a part of the Patriot Act, but this is a pre-existing statute. Under this statute, there is no requirement to prove the identity of a specific victim or of a specific country in which the attack occurs. And in fact, that's true of both of the statutes that I've talked about so far. And so what this statute covers is kind of a classic notion of terrorism. It's the conspiracy or the act of getting together to kill victims regardless of who they are or where they are, but to kill them for some perhaps political motive, what have you. But there is no requirement to prove a specific identity of victims or location of the attacks. And this, too, has a maximum penalty of life. These kind of statutes, as I mentioned, because they give similar penalties for conspiracies and attempts for the actual commission of as they do for the commission of the crime itself, criminalize what's known sometimes as a dry conspiracy. That is a conspiracy that is a conspiracy but does not actually accomplish its goal. In the case of a conspiracy to kill, no one dies. The conspiracy is frustrated, but nonetheless the conspirators are charged with and penalized as if someone did die. And in the context of terrorism, I'd submit to you that penalizing and prosecuting these so-called dry conspiracies is perhaps even more important than it is in other contexts, because the point of terrorism prosecution is to prevent and to stop people from accomplishing such terrorist attacks. And so therefore, while dry conspiracies are prosecuted in all kinds of contexts, narcotics, bank robbery, what have you, I would submit that they should be prosecuted more often in the terrorist context, and in fact, that they are. It raises issues of when is it time to prosecute, when should you continue to gather intelligence, when should you file charges and therefore give up the fact that you're conducting surveillance of someone, perhaps by a wiretap or through contact with an informant. And it raises issues of prosecutorial discretion as to when do you have enough you suspect that someone is going to or is planning the commission of a violent act, but it hasn't happened yet. And so you need to draw a line of when you think it's time to intercede and to charge, and to be sure that you have what you believe is evidence to prove the case beyond a reasonable doubt, or to let it continue to be more sure. And those are issues that may come up in questioning or that you can think about on your own. The next category of statutes that I want to talk about, and obviously there are many more that I'm not getting into right now, but the next category that I want to talk about is those that are used against people who are supporting terrorism. And there are two in particular that I want to mention. The first, they're both known as the material support statutes. One of them, again in Title 18, is Section 2339A, and that is used to prosecute people who are providing material support or resources to various enumerated criminal conspiracies or criminal acts, including the ones that I've already mentioned. And it is a crime to provide material support or resources to such a criminal enterprise, for example, a conspiracy to kill abroad or within the United States. And material support is a crime that has also pre-existed the Patriot Act. It was added, 2339A, to the code in 1994, not after 2001. The penalties were increased in the Patriot Act, though. And this statute has been used historically. For example, there was a prosecution in connection with the Millennium Plot in the Southern District of New York that was brought, and also in Seattle, I believe. There were two cases brought related to that incident. And just to give you an example of why somebody might be prosecuted under this statute rather than the other ones that I mentioned previously, that is those that focus on the perpetrators themselves. For example, imagine a border guard who allows a suicide bomber to enter into a country not because they want the person to succeed in their attack, and not perhaps they deplore the goal, but because they were paid off. And they did it for a monetary goal, and their motive is different than helping the person accomplish their goal, but they know why the person is crossing the border. Or a weapons dealer who sells weapons to someone who knows that they're going to use them in a terrorist attack. They don't want them to succeed. They don't care if they succeed, but they do it for a profit motive. And people like that can be prosecuted under this particular statute. The second statute in this category of those who support terrorism is Section 2339B, another material support statute. And again, this statute, although the penalties were increased in the Patriot Act, pre-existed the Patriot Act. It was added in 1996. And some of the interesting issues that arise here is, what is the intent requirement? This statute prohibits the provision of material support or resources to a foreign terrorist organization. And there is a list of foreign terrorist organizations identified by the State Department, and it lists some that you would expect, like Al-Qaeda, and it lists others that you may not have heard of. And this statute raises interesting issues surrounding the intent requirement, because what is the intent requirement? Typically in criminal statutes, it may be that you act knowingly, which is you act not by accident or mistake, but you act purposefully. But in this situation, if that were true, then if you knowingly provided money and you had no idea who the recipient was, then that would obviously be a very, very broad application of the statute. So instead of that courts have typically interpreted this statute as requiring knowledge that the recipient of the material support is a foreign terrorist organization. And so, for example, if a person, and one of the places that this comes up very commonly is in the donation of money context. If a person donates money to a designated foreign terrorist organization, for example, Hamas, they can be prosecuted for providing material support, which includes in its definition currency, for providing material support to a foreign terrorist organization. Let me give you one hypothetical. I don't want to go on too long, but let me give you one hypothetical that you can think about. Imagine a person who goes to a rally, and at the rally there are speakers who are speaking about how Israel should be destroyed and how also that people in Palestine are being mistreated and that they're trying to raise money to accomplish things toward these ends. And at the end of the rally, they ask for money, and they ask that the money is going to be donated to an organization called Justice for Palestine. In the situation where someone donates money to Justice for Palestine, it's probably not a situation where, absent evidence that the donor knows that Justice for Palestine is a front for Hamas, that they can be prosecuted. But in contrast, if the organization is identified and the recipient is identified as Hamas, even if the donor believes or wants their money to be used strictly for humanitarian purposes, if they know that the recipient is Hamas, which is a foreign terrorist organization, they can be prosecuted. And that has raised issues in the courts around the country. I'm not going to get into all the detail about it now, but it raises interesting questions about association and where the lines can be drawn in terms of the provision of support to terrorist groups. And finally, the last category that I want to mention briefly is the prosecution of people who are associated with or suspected of participating in terrorist crimes for non-terrorist offenses. And those include immigration offenses, visa fraud, credit card fraud, bank fraud, transportation of stolen property, just basically any crime in the books which might be applied to someone who is thought to be participating in or committing or associating with people who are committing acts of terrorism. And this raises issues as well. Some academic literature has criticized, as I mentioned at the outset, the broken windows theory of prosecution, which is you prosecute turnstile jumpers in New York, and you hope that someone who you prosecute might either have committed a crime in the past and you catch them, or you have caught somebody who might commit a crime in the future. This is different than that, because what happens in this situation is people are identified who are thought to be threats, like Al Capone, and they are prosecuted for statutes that are on the books and that they are in violation of. And so, on the one hand, while people might raise issues about the exercise of prosecutorial discretion in this context and ask questions about whether it's appropriate to charge people who you think are perhaps guilty of one thing but prosecute them for something else, I'll submit to you that you can think of it this way as well. The people are actually violating the law. They are being prosecuted for violating the law that they are violating, and a jury will decide whether or not they are guilty of that violation. And I'd submit to you that they don't have a right to be free of prosecution for those violations. And so when the criminal law is used in that context, it can be an effective tool, one that has been criticized in academic literature in some context, but an effective tool in rooting out terrorism before it happens. And finally, I would say that another mechanism that's been used in this context similarly is the use of the material support statute. And that was used to investigate, and has been used and continues to be used to investigate acts of terrorism and to inquire into material witnesses. And there's been some criticism about that as well, but I'd submit in this situation, the measure is not whether those people are ultimately prosecuted for crimes of terrorism, because in the context of terrorism, as Andy mentioned and as I mentioned at the outset, the goal is to prevent terrorism. And if the material witnesses are interviewed and they are found not to have committed crimes of terrorism, that really is a good thing, because the use of the tools like that to investigate is something that I'd submit we want to do. We want to find out before things happen whether there are plots and whether they can be stopped. And so those are the three different types of statutes that can be used, the three different categories of cases. And if there are questions about that, I'd be glad to talk about them more. But at this point, I'll turn over to James.
Thanks, Tony. James Candelmo, our final panelist, was appointed the Anti-Terrorism Coordinator for the Eastern District of North Carolina just a few days after 9/11. And in that role, he coordinates anti-terrorism efforts among 50 federal, state, and local law enforcement operations, including the FBI, INS, Secret Service. He's a 12-year member of the Department of Justice. He has extensive experience prosecuting white-collar crime in the fraud section, and he also worked in DOJ's elite internal security section to investigate and prosecute espionage. I had the opportunity to talk to Jim last night, and he really has an encyclopedic knowledge of this area, and it's my pleasure to introduce him now.
Thank you, Jonathan. Thank you, Dean Bartlett. Thank you, Tyler, for putting this together, and thank you, Duke Law. I've been in the habit of thanking Duke Law more times than I ever thought I would be since 9/11. Professor Silliman, Professors Beal, and my trusted ally in front of me have provided an informed, candid and clear discussion of our anti-terrorism policies, our federal prosecutorial function over the years, and for that I'm extremely appreciative of. I want to try to give you from the ground up a organizational, possibly law enforcement, U.S. Attorney's Office, cultural perspective of where we've been, where we are, and I think maybe where we're going in light of this counterterrorism threat. I'm going to warn you, I probably will use the word paradigm several times during this discussion. However, my own self-inflicted rule of not using paradigm and synergy in the same discussion, I will avoid the use of the term synergy. So please bear with me. North Carolina is an interesting example, and I think it's kind of a microcosm of the United States, as I'm sure a lot of other places are, not just geographically. We have the mountains, we have the lakes, we have the ocean. Economically, we have agriculture, we have high tech. We've got various energy sources here in this state, and we are a major military projection platform for virtually every branch of the United States Armed Services and the Coast Guard. What I think this does is it provides a backdrop for exactly how do we meet this threat or how we've responded to this threat along that various range, diverse range that we face. I'll tell you where I think we were. When 9/11 happened, what you as citizens had at your disposal was an incredibly dedicated group of men and women involved in law enforcement and as our prosecutorial function. However, the mission in no way, possibly outside the Southern District of New York, did it reflect the terrorism threat that we are today presented with. In the hours and minutes after 9/11, that threat was identified, that mission was identified, and the dedicated men and women of law enforcement worked nonstop. I think the Charlotte Division of the FBI did over 7,000 leads in the weeks after 9/11 in North Carolina. However, we had to refine how we could prioritize things, how we could allocate resources, and where exactly we were going to place the emphasis on that mission. Where were you at that time, pre-9/11? You were an American public that didn't know of roving wiretaps, didn't know of the Foreign Intelligence Surveillance Act, and if you did know about it, you thought we were targeting the Soviets at the time, and that we were maybe targeting organized crime figures and Colombian drug cartels with these law enforcement techniques. in regards to the anti-terrorism or counterterrorism mission, it was something that you would see on the news, and I'm talking of my own perspective on this. It's something I would read about, knowing Mr. McCarthy's work, Mr. Garcia, who you'll hear from, and Henry DePippo, who prosecuted the 1993 attacks on the Trade Center. But so I put myself with you in that world. Where were you on 9/11? Everyone's going to remember that. But more importantly, where were you as where you wanted this country to go? And I think that was a process that we had to undertake. I think the passage of the Patriot Act, Professor Schrader and I discussing the passage of the Patriot Act, what it was, what it wasn't, you participating in that debate, Congress voting on those matters, and then as law enforcement, us using those tools that are provided to that was a process. And I think it's probably an ongoing process. I think we can make an argument for the viability of many of those tools that we use today. Where are we now, or where are we headed, I guess is an important question. One of my first bosses said, where you stand depends on where you sit. And I think that's no more appropriate than as we look at this threat of terrorism and how it's facing us today. Where are we as far as law enforcement? I am not. I am an assistant United States attorney. I do no way do I face the threats and the occupational hazards that law enforcement, many of the men and women who are here today, face. I respect them immensely. But I can tell you as a consumer of them, I can tell you where they are. They're directed, they're engaged, and they're committed. Special Agent Kevin Kendrick being here today is one example, but if that's all you took away from this, you'd be missing the other 99% of what him and his organization are doing. Serving on the Executive Council of Joint Terrorism Task Force for the state, which sits in Charlotte. There are active operational Joint Terrorism Task Force satellites throughout the state and throughout the Eastern District of North Carolina, which are a reflection of the priority that the Charlotte Division of the FBI has placed on this anti-terrorism mission. They are goal-oriented, mission-oriented, and that's where I think that's a fair example to tell you where they are. Now, the paradigm from which I see this all with, my formative training in this matter, I was as a counter-espionage prosecutor. Counter-espionage in this regard is maybe addressing something Mr. McCarthy said earlier. Where is counterterrorism? What role does it play? And what does prosecution and the individuals in this room and on this panel play in that goal and that mission that we face? Much like counterespionage, prosecution is only one piece of the entire mission that we run up against in counterespionage. There's disinformation, misinformation, deception, things that you would think of as the actions of intelligence agencies. Prosecution may be a position to disrupt an agency, a foreign intelligence group, things like that. I view that the same way as our counterterrorism mission. I believe that a good part of counterterrorism occurs away from my desk, my office, and through groups as the Joint Terrorism Task Forces and other national organizations. But more importantly, I think I'm a piece, or our office is a piece of that. And because of the sensitive nature of it, we have to be involved from the beginning. So much like a counterespionage case where we're brought, a prosecution or a United States Attorney's Office is brought in an extremely early phase. Decisions have to be made, decisions, philosophical decisions, preserving, Mr. McCarthy said, preserving the intelligence equities that may be involved. Certain times, a prosecution is capable, whether an administration wishes to possibly compromise sensitive sources and methods, have to be weighed in because the defendant is going to have a due process and a fair trial. We're going to have to weigh all those things together. In my role, pre-9/11, I was a prosecutor. We prosecute criminals. Now, part of my mission and role is disruption, and I understand that. And as Anthony was eloquently put, there is a reasoned, rational disruption function that the prosecutors and law enforcement now play in this very valuable, important mission. The most important thing that I want you to take away from this is a process. This is not done. We do not have a system of which we are going to live with and work with. As position in the United States Attorney's Office, I work with many law enforcement agencies: Immigration, Customs Enforcement, Marshal Service, State Bureau of Investigation here in North Carolina, and we end up being a very good place to be able to know what's going on. The old saying, you don't know what you don't know. If I see activity in one of those departments, they may not understand how it might be related to a sensitive investigation that the Joint Terrorism Task Force is undertaking. I might be in a position to put those individuals together and then further our mission there. But it's a work in progress, to say the least, and I invite or I welcome these kinds of opportunities to discuss it. So thank you very much.
Okay, it's all you. Professor Sullivan.
Andy, let me follow up on the comment you made where you stressed the two different options, either prosecution in the federal courts or military commissions, and I think you said neither one is really satisfactory. Is there any serious consideration being given to creating an Article I court, perhaps on the model of the Foreign Intelligence Surveillance Court, that would be specifically suited for the trial of terrorism concept doesn't exist right now? Is there any serious consideration going to Congress and asking for that?
I believe there is serious consideration being given to that, and I think it proceeds on two tracks and would address two things that are extremely important. Number one, the main problem that we deal with in trying to apply the criminal justice system as it exists in all its fullness to what we do is the compromising of intelligence. The discovery burdens in a criminal trial are enormous. Basically, under the rules of criminal procedure, we turn over anything that is material to the preparation of the defense, which is a very loose standard. We turn over all prior statements of government witnesses. We often have to turn over even statements of people who don't appear as witnesses, but whose evidence comes in as hearsay. And the Brady standard is very broad. Brady started out as a due process rule where the government was just required to turn over exculpatory information that was uniquely in its possession, and it has gotten, as such rules can be expected to over time, broader and broader to the point where it's more of a standard of what information does the government possess that could be helpful to the defense. Those rules, I think, in the context of the normal criminal defendant, where we presume innocence, and as I said before, would prefer to see the government fail than run the risk of an innocent person being convicted, it's entirely appropriate to have those kind of standards. But I think what's underway and the discussions that are underway are how would you reasonably tailor that down so that we can come up with a due process standard that comes up to a level that we can be proud of as Americans, but does not vest our enemies with the full panoply of rights that we would give a tax cheat or an accused tax cheat. So I think that discussion is underway, and a lot of different factors go into it, including, whether someone is an American, in which case I think there's probably very little one could do to clip the array of rights down, and in the other camp, whether if someone is an immigrant, it will depend on how much of a connection with American society the person has. So that's one component. And the other component is, can we, because the Supreme Court, when it opened the doors of the American courts to the unlawful combatants who were housed at Guantanamo, but didn't give us a lot of guidance on what procedures those habeas proceedings were going to have. The theory on which the court opened the doors of the U.S. courts was that the habeas statute required it, not that it was a requirement of the U.S. Constitution. So Congress at any moment could amend the habeas statute to drastically change the analysis that resulted in these habeas claims being filed. And Congress might do that, but also take the opportunity to, which frankly I think it should have done long ago, to give some consideration to procedures of due process that we would be comfortable imposing in the situation where we have people who are held for a considerable period of time without charge in a war that is, frankly different from the normal war that we've had in the past.
I'd like to recognize Special Agent in Charge Kevin Kendrick and introduce him to you and ask him if he has anything that he'd like to add to the discussion or any questions that you'd like to ask the panelists.
Actually, no. I'm just honored to be here. I think Mr. Candelmo said it all from the law enforcement perspective. I'm just very honored to be here. I appreciate Duke sponsoring this. I would like to hearken back to some comments that Mr. Stone made also. It really is all about leadership and friendship and partnership. That's where it all starts and that's where it all ends. Thank you for having me here today.
What other questions? Do you have a question?
Well, my question was similar to Scott's, starting with Mr. McCarthy and then perhaps continuing with the prosecutors in terms of what changes, if any, you saw as necessary. So I guess the third way, part of the third way could be what Mr. Barkow was suggesting, different offenses which capture at an earlier point in time conduct preliminary to blowing up a building or kidnapping a person. But the other third way could be in terms of procedures. So you talked about everything from security problems to release of intelligence information. What would be the procedures that you all would think would be most necessary and appropriate to put into the hopper for discussion in this balance of rights of individuals, fairness versus being able to achieve the objectives?
Briefly, I would put everything on the table up for discussion, even trial procedures. I mean, I would like to see, what I would like to see happen is the FISA court get expanded and have jurisdiction over actual criminal offenses so that we could develop a single court with a single standard that would have expertise in the matters of national security that we deal with. I would like to have that court have jurisdiction over the kinds of crimes that we commonly see in national security context. And then I'd like to see a thoroughgoing discussion of not only things like SEPA, where that can be tweaked, and FISA, but also what would trials in that court look like. And I think a lot of that will depend, as I said, on the status of the defendant. But I think that there's a lot of thought that needs to be given to how you clip discovery down so that you can have a trial that meets due process standards, so that it's fair, but that we're not giving away the store to the enemy in the middle of a war.
I think that the discovery obligations, one of the things I would say is that in a traditional law enforcement context, prosecutors tend to interpret their discovery obligations even more broadly than the discovery obligations have been interpreted already. And so the Brady standard has, in some court decisions, become a will it help the defendant standard. And as a prosecutor, you go even further than that. I mean, you turn something over. People talk about the gut check standard. If it feels like something you'd think about turning over, you turn it over. That's not a great standard to apply in a situation where, when you turn it over, you could be putting people's lives at risk. And it's something that you think about in the traditional law enforcement context, where you have just in a violent crime case where you would be producing information relating to a victim, and you have to draw the calculation differently in that kind of a context. And certainly when the consequences are more broadly dispersed among the general population, I think you have to do the calculation even more cautiously. And so I think that it's a good idea to think about erecting systems that think about discovery in different ways and Brady in different ways while still protecting defendants' rights. And perhaps, and I don't know much about this context, but there could be some consideration given to if defense counsel are cleared to receive information, they could receive more information than their client, and therefore the defendant actually, their rights could be protected more than they might be today under whatever systems we have. It would be a different type of protection of their right because they're not getting access to the information, but they would, if they had a good lawyer and that process was ensured, then they would have perhaps even a better opportunity and better access to information than they have now in certain contexts. So I think that's something that could be considered as well.
I think the interesting thing we're going to be faced with is that the reactive nature of some of these prosecutions in the field of terrorism makes it extremely hard to balance the equities going in to the prosecution, something that we typically can do in a lot of other cases. But when we're doing a reactive prosecution and an investigation, the equities are already involved. And then it's almost a decision of whether we're going to prosecute at all or not. It really hampers our ability to control how big the field of play is going to be heading in. I'm concerned about our ability to organizationally create a system that will be able to handle those things because of just the ultimate reactionary nature of this threat.
This discussion leads me to something that I was discussing last night with Admiral Stone, who is in charge of trying to find terrorists, trying to prevent terrorists from getting on our airplanes, but is screening the entire population. And the question that I posed to him last night, which I'd like to discuss now, is how do you protect individuals' rights, prevent what all of us assumed was going on some level after 9/11, which is racial profiling?
Exactly. For the TSA, and I know for the department, this idea, this concept, the belief that obviously it's imperative that we preserve those freedoms that we all love and treasure is key. And so one only need look at Jose Padilla, Richard Reed, the Unabomber, the Oklahoma City bomber. Terrorists come in all shapes and sizes. You can't make and should not make these decisions based on race, color, creed. I think that is, we've done a very good job in imbuing that concept into our organization and throughout our department. That very theme that what we're focusing on is behavioral pattern characteristics. For instance, if you go to Portland, Maine today, or Boston, or Providence, Rhode Island, there the TSA screeners are involved in a pilot program in which they're trained to behavioral pattern characteristics so that they can then refer to law enforcement at those airports, individuals that appear to be behaving in such a manner to cause concern. So we believe, after those pilot results are reviewed, we intend on briefing them up through the Department of Homeland Security, that there's a real value added to that approach for expanding that nationwide to train our screeners in behavioral pattern recognition and partner with local law enforcement regarding that, as opposed to stereotypes and profiling that based on race, color, creed, that makes you a terrorist. And as I mentioned, there's a long and distinguished list of documentation that indicates that is certainly not the case, and that terrorists do come in all shapes and sizes. I also add that we're also very much aware from intelligence that Al-Qaeda and other groups are working very hard to recruit individuals that they believe, based on stereotypes, will not be viewed by your average person as being a threat. And so all that lends it to believe that I think we're on exactly the right course within TSA and the department on how we're approaching this business of screening, and also our interest in professional behavioral pattern recognition training.
What other questions? In the back there.
I don't have a microphone, so I'll just try to be as loud as possible. I was wondering if you could comment on the the renewed discussion that will happen at the end of the year about the Patriot Act, in light of the divisive confirmation of, well, for three of you, your new boss, Alberto Gonzalez?
I really don't see the two issues necessarily as related. The confirmation hearing was divisive in a sense, but, once the Attorney General becomes the Attorney General, he doesn't get 2/3 of the power, he gets all of it. So, he's going to function as the Attorney General. I expect he and his very able deputy, who's been a friend of mine for about 20 years, Jim Comey, will be very, very able advocates for the Patriot Act. The Patriot Act is probably the most maligned piece of legislation of recent memory. Most of the controversy is difficult, frankly, for people who do what we've done for years to understand, because most of the things that have been regarded as controversial are things that criminal prosecutors have done forever. And if you lost the powers, let me just give you one example, the so-called library provision that doesn't say library. These are third-party records. They're business records, basically. Prosecutors in criminal cases have, for years, been able, without any court supervision, and really without any meaningful supervision at all, been able to obtain those records by simply issuing a grand jury subpoena. The protections that you actually get in Section 215 of the Patriot Act are much higher compared to what you would deal with in the criminal context. I think the government has made a tactical error, frankly, in blaring that you need to get a court order to get these records, because it's really, let's be honest, it's more like a rubber stamp court order. That doesn't mean it's an unimportant act going to a court, but they're much more like the court orders that you get in criminal practice to get a pen register, where if you say the magic statutory words, the court has no choice. It doesn't really have discretion. It has to issue the order. But nevertheless, it's important to make the government go through the process of getting a court order, and it also facilitates congressional oversight, which is something I think people need to bear in mind. So, 215 is one of the ones that there's been such a hullabaloo about. I frankly don't see it. I'm sure I bring my own baggage to that equation. But
Yes.
Secretary Stone, you mentioned the registered traveler program and biometrics and also secure flight.
Yes.
What are your thoughts on the possible national ID card system and any benefits and disadvantages that might have, particularly with the TSA and checkpoints within the country?
I just think in general, the desire to have verification of ID is something important to us. The means in which we do that, we're still reviewing how best to do that. And in fact, on secure flight, one of the issues that we're investigating is there value for us when you buy your ticket to access commercial databases to verify identification, so that we can do a better job of not only adjudicating your name against those that are on a list, but also to ensure that we have the sort of fidelity that we really need to make sure that we're doing a good job on identifying those that would do us harm as they come through our airports and are on that list. So verification of ID is an issue that we owe a report to Congress in March on what type of protections we would have in place if, in fact, Congress were to give us permission to use commercial database testing to verify ID as part of secure flight. So I think that we're often criticized about why is it taking so long, why is this process so slow? Well, when you're talking about an issue like preserving our freedoms in the core of what we believe in, that should be a thoughtful process, and TSA and the department's approach has been to make sure that we're carefully reviewing that and presenting to Congress our proposals on firewalls and other safeguards so that we get the right balance between making sure that as we go down the road of wanting to verify ID, that we're not doing harm to those privacies and freedoms that we enjoy. And so that's a very difficult issue that you talked about, because preserving the freedoms is a very big challenge and an important one.
Yes, sir.
Admiral, my question deals with operational perspective to combating terrorism in the future. The federal government makes funds available to the states for equipment and training. What is the comfort level of the department on the wise use of those funds by the states and indeed filter down to the counties, parishes, and cities?
It's difficult for me to accurately portray the department level view of that. Although I know in my meetings with Secretary Ridge and Undersecretary Hutchinson and Admiral Loy, the desire to ensure that that flow of funds to state and local levels is accelerated and expanded upon is a very real priority for the department. Almost every opportunity, the theme of Homeland Security is really hometown security. The real power of it is out in the towns and villages of America is where you need to get that. I think resonates through the department. There's the desire to do that and do it better. Certainly at TSA, and a year ago, our own organization was very much a headquarters-centric organization. All of our testing, our training, and our hiring was controlled out of Washington, D.C. A year later, that's all now been moved to the field, where testing, training, and hiring is done locally. We've moved all of our area directors out of the headquarters to the field. The concept that that's the real power of Homeland Security is locally, I believe, is the strategic direction we're headed on, and you'll see us to continue to move that way.
Professor Schrader, did you have a question?
Yeah, a question for the prosecutors and former prosecutors. I mean, crudely put, once you've got a lead that's got some fruit to it, you've got the possibility of continuing surveillance, of disrupting the operation, or ultimately prosecuting for a crime, or some mix of those. And each one, as you've said, requires different evidentiary demands, and you have to weigh different factors as to the value of that continuing the surveillance and so on. How does that decision actually get made? I don't want, recitation of the factors, but just organizationally and operationally, how do you make that decision? Is it done at the U.S. Attorney's Office locally? Does it go up to Washington? I can imagine cases in which you're working on things that might have intelligence value for something that we're doing overseas that could pass on information to an agency outside of justice. So how do you vet those decisions and try to get all relevant information about when a move should be made on the table before you act?
Briefly, in my experience, I think it's as you would expect. Depending on the sensitivity of the issue really determines how high up the decision-making chain the decision goes. At the level of some of the cases that I mentioned at the end of my talk, where you're talking about credit card fraud against someone, I mean, that could be something that's made at the individual AUSA level in consultation with a supervisor in that unit. When you start getting into things of more sensitivity, you go further up the chain to the U.S. Attorney, and when you get to things of national sensitivity, of national intelligence gathering sensitivity, you go down to a high level at Main Justice, and there would be consultation with other agencies at a high level as well. So, I mean, it would really be, I think you could use a common sense analysis really and kind of figure it out, because the more the tentacles reach out and affect other things, the higher and more widely dispersed the decision-making would be.
SAC Kendrick's here, and I don't want to put him on the spot, but we viewed in our office largely as an operational decision. And operationally, we go run everything through our JTTF in Charlotte. So I don't want to put you on the spot, but I think he has something that he could probably add to this, at least this part of the discussion.
I would just concur in what both of you have said. It really depends on the circumstances of the individual case. The Joint Terrorism Task Forces that are in play within North Carolina truly are joint, and decisions that are made whether to continue surveillance affect prosecution on a particular matter, or whether it should be elevated to a national level. But in all cases, we do consult with our partners.
Yeah. I should add to that most terrorism cases, at least that come to us as investigations rather than something that we have to react to because a terrorist strike has happened, don't present as terrorism cases. They'll ordinarily present as something seemingly, ostensibly much more minor. Again, you can't divorce any generalizations away from what their actual factual contexts are. But we've gotten leads on people who had, as it turned out, valuable terrorism information from, fairly petty fraud cases, from, money laundering cases, from a variety of different crime that you wouldn't, off the top of your head, when you first saw it, necessarily say, terrorism.
I think we're going to have to wrap it up, folks. We went a little bit over because we started a little bit late, but thank you to all of our panelists, thank you to the law school, and to Tyler for setting this up, and thank you to you for your questions.
So, a quick logistic.